Welcome to the People's Law School. My name is John Brinkley, and I'm a trial lawyer and a member of the Alabama Association for Justice. We're here to hear from Judge Coates about juvenile court and about capital murder cases. These are two interesting things on opposite ends of the spectrum in the legal world, but what you're going to hear is that Judge Coates has a whole lot of experience in each of these. She got her law degree from Mercer University there in Georgia. She's a Birmingham native, and she's been working here in Madison County as a DA starting in 1988, 92. And during that time, she had an opportunity to prosecute people, and she also prosecuted people who were not nice to children. And that's one of the things that the district court does primarily, or it has exclusive jurisdiction over the Department of Human Resources cases. Judge Coates is an advocate for little children. What you're going to hear is that through her time as a solo practitioner in her private practice, she had the opportunity to work in the same building as her father, who's an accountant. She is well versed in accounting. She can pencil whip you if she can see your tax return, which is something I learned from another attorney that once Judge Coates in her private practice was given someone's tax return in a child support case, and the other lawyer who didn't know what they were looking at was able to arm Linda Coates, merely the lawyer, and she chewed him up and spit him out with the information that was contained on the tax return. So what you're going to hear tonight is someone who's well versed in the law. She's also a tax preparer. She's about to sit for the CPA, I think she'll tell you. But she knows a lot about what she's talking about. She has been a steward here in our community for many years. She was one of the earliest attorney Republican voices that you would hear some 20 years back. She has been the secretary and treasurer for local Republican clubs here all across Madison County. And she's also a quilter, which I learned tonight. I did not know that she knows how to sew bridesmaids' dresses in addition there too. But you're going to hear a lot about this remarkable young lady. Her name is Linda Coates. Thank you.
Good evening. So we have two ends of the spectrum to talk about tonight. I hope that you'll enjoy both. I was privileged to be able to practice in juvenile court representing the children and representing parents for 16 years. And then I went to be contract counsel through the Alabama Attorney General's office to represent DHR in the state. So we're going to talk about that first, and if you have questions, just raise your hand, and I think I'll try to take questions as I speak about this. Juvenile court is handled through the district courts primarily in the state of Alabama. We have circuit court and we have district court. I'm assuming y'all have learned about circuit court and district court. Yes? Okay. So some of the counties, some of the circuits in the state of Alabama have their juvenile court judges or also their circuit court judges. But most of the time you find your juvenile court judges are the same as your district court judges. There's no juvenile court judge that just sits by themselves as juvenile court judge. They're either a district court or circuit court. They're elected one or the other. So we don't have any exclusively sitting or elected juvenile court judges. In Madison County, it's handled by the district court. And primarily, we handle the juvenile delinquency, which I'll touch on just a little bit, but the vast majority of my time in juvenile court is spent in the child welfare cases, where the state of Alabama has had to come in and take custody of children due to abuse or neglect. Up until, I'm not real sure, I didn't look this up, 60 or 70 years ago maybe, the probate courts of the counties around the state handled the orphans court. That's what it was called, the orphans court. And you'll find that going back all the way back to the foundations of the country, orphans court. And that was for children whose parents had died. They really didn't have a mechanism for child welfare and abuse and neglect. It was deceased. It was true orphans. And as we had the child labor laws come along in the early 1900s and more child protection, is how we came about to have what we call as the Department of Human Resources to investigate reports of child abuse and neglect. And along with that came some statutory authority. It was codified. Have y'all learned about common law and statutory law? Have y'all learned about that? Okay. All right, so the juvenile court welfare cases, we call them dependency cases. They're dependent children in that there's no parent willing or able to give proper care to these children. They're called dependent children. They're not called orphans, but you could call them orphans because an orphan has no parent who's willing or able to take care of them. So they're called now dependent children. And it's a whole section of law by statute, okay? There's no common law scheme for child welfare dependency law. It's all statutory. We had, and we still have today, what's called common law unfitness, and this is where a lot of lawyers get confused about it. Common law unfitness goes all the way back to the foundations of the country, back to England, where parents were not fit, and you could take a parent to court and show that they were not fit, and you could gain custody of that child, parental unfitness. And so that also predated the Department of Human Resources. Well, that still exists today. Anybody can take a parent to court and say they're unfit and I want custody of this child, and they have to prove it, and that would be in circuit court. That's not juvenile court. That would be in circuit court, the court of general jurisdiction in the state of Alabama, because you're not proceeding according to the statutory scheme of dependency. Even though the elements are the same in both sets of cases, you can proceed whichever one you want to go to. The lawyer can decide which forum that they want to proceed in. Y'all with me so far? Yeah. All right. So when DHR gets a phone call from anybody, a citizen, a mandatory reporter, have y'all heard the term mandatory reporter before? You'll hear that on the news sometimes. Mandatory reporter is set out by statute. They are school counselors, daycare providers, doctors, psychological counselors. There's a whole list of people who are mandatory reporters, and if they see any type of child abuse or neglect or suspect it, then they are responsible to turn it in. And if they don't, it could be a misdemeanor offense for not turning that in. So cases are started by a report being made to the Department of Human Resources, and they assign it a priority. So based on the allegations, they assign it either a 12-hour priority, in other words, they've got to send somebody out within the next 12 hours to investigate this, or they assign it, I think it's up to 10 days. I think they might have a 3-day priority and a 10-day priority. That's set by the policy of the Department of Human Resources. That's not set out by statute. But they have like this triage that they try to grade the cases as they come in. And if they find that the case is warranted, then they can bring a petition. Well, they can do several things. They can provide services to the parent there to prevent filing a petition, or they can file a petition with the juvenile court, opening it up to the juvenile court. And when they do that, they're always asking for custody of that child. So they would open the case, and then a guardian ad litem would be appointed to represent the child. In the state of Alabama, you have to have an attorney, a licensed attorney, to represent the best interests of the child. We don't presume that the state knows exactly what should happen with the child, and so we have guardian ad litem to protect the interests of the child. Also, the parents can receive a court-appointed attorney if they want to. This is the only area where crimes are not involved where they're entitled to a court-appointed attorney. And the reason they're entitled to a court-appointed attorney is because your right to parent is a basic constitutional right. And so if the state is coming in asking for custody of that child, they're being deprived, their constitutional rights are at issue, and so they are entitled to apply for a court-appointed attorney. The dependency statutes also allow for any interested party to bring a dependency proceeding. It doesn't have to be the Department of Human Resources. By and large, it is the Department of Human Resources. They probably have 90% of the cases. But you can have a private individual come file a petition, and they get confused sometimes because there is a lot of statutory hoops that you have to go through to give jurisdiction to the juvenile court. So you really need to know what you're doing if you want to file a dependency case in juvenile court outside DHR. So the case starts going, and we set it for what's called temporary legal custody hearing. And what that is the hearing on the petition. It has to be held within 60 days of the filing of the petition, so it goes very fast. There's very little discovery. Have y'all talked about discovery? Yeah, okay. There's very little, if any, discovery. And it's set for temporary legal custody, which is a hearing on the merits of the department's petition. And we determine usually there's not any contest. They will stipulate, is the word we use, to dependency of the child, and that means the child is then declared a ward of the state, and then we proceed through the dispositional phase, which could last 2 years, several years. But the significance of that first hearing is that that is a hearing on the merits of the petition to determine if the child is dependent, if the parent is unfit, and that's where your case is. And a lot of people forget that. The attorneys just blow right by that, and they get in this case a whole year down the road, and they want to contest something. Well, guess what? It's too late, because it happened way back at the very beginning where that child was declared to be a dependent child. And once a child is declared a dependent child, then there's a whole lot of discretion with the juvenile court. And any hearings you have past that, hearsay is admissible. Triple hearsay. You can get triple hearsay in. You can get any kind of, hearsay you want to. Now, what level of weight we give to that hearsay would be at issue. Be up to the judge's discretion how much weight they give the hearsay. But every proceeding that happens after that, hearsay is admissible. The judge has just almost total discretion about where the child should be placed, whether the child should go back with the parents, what kind of visitation they should have, whether they should keep the case open, close the case. And so that, in a nutshell, is the process of a juvenile child welfare dependency case. Yes, sir?
You use the word child quite a bit.
Yes, sir.
What's a child?
Under 18.
Oh, under 18.
Under 18. Here in the state of Alabama, the age of majority is 19 to contract. But the child welfare laws are governed partly by federal law also, and so that's why the Department of Human Resources cannot pick up a child who has reached their 18th birthday. So you won't see a case commenced about a child who has reached their 18th birthday. Now, if they are found to be a dependent child before their 18th birthday, then the juvenile court can retain jurisdiction until they're 21. And that applies to dependent children, and it also applies to juvenile delinquency. In Madison County, we are also very fortunate to have what's called the Court-Appointed Juvenile Advocate Program. That was a program started about 25 years ago. I participated in it in its very, very early infancy stages, and it is a true asset that we have here in Madison County. What I have found is that our social workers carry about twice the load that they're supposed to carry. There's just not enough funding to hire enough social workers to take care of the kids that we need to take care of. In Madison County, at any given time, we have about 500 children in foster care. So, the social workers have twice as much as they're supposed to have. The guardian ad litems, they're not trained social workers. They're lawyers. And so they're good at what they do, depending on if they're dedicated to the child. We have some that are not dedicated to the child. That child is a client. That child can't really complain about their lawyer. They don't have any way to do that. And so, unfortunately, sometimes we don't have guardian ad litems who are as good as other guardian ad litems to advocate for the best interest of the child in these cases. So what Judge Hartwell Lutz, he was a juvenile court judge from, help me, Alan, late 70s to the mid-90s, I think?
I think you're right.
Okay. So he started the Court-Appointed Juvenile Advocacy Program. He passed it. He was a legislator, and he got it passed through the Alabama legislature. And part of our court costs help fund the director's salary. The rest of them are volunteers. And all of the court-appointed juvenile advocates themselves are volunteers, and they go through a pretty extensive training. And they have the role in the best interest of the child, very similar to a guardian ad litem. They usually work together with the guardian ad litem, although there are some cases where they would disagree. So they provide very valuable assistance to the court, especially in the dispositional phase. Once it gets to the dispositional phase, then they become the eyes and ears of the court. They can testify, they submit reports, and so they're very valuable. They only carry 2 cases, I think, at most. So that's child welfare. Briefly on juvenile delinquency. Juvenile delinquency is a child who's charged with a crime and the child is under 18 at the time of the commission of the offense. So I know you've heard on the news sometimes where somebody might be 26 but they're charged as juvenile. I think there was a case up north where there was a rape charge or something that came down and the person was 26, but it was alleged to have occurred back when they're under 18. Well, they're protected by juvenile court, and that's under the premise that the whole scheme of the criminal justice system is the intent of the mind, that your criminal intent. It's not an accident, whatever it was that you did, you formed the intent, and there is a lot of psychologists and psychiatrists who say that the mind of a juvenile is not developed where they can form that intent that's necessary to convict someone of a crime. So that's how we have the whole juvenile delinquency scheme. There are 2 bills that are very interesting that are pending right now in the Alabama State Legislature that would change significantly some of our juvenile delinquency cases. One is, well, not really juvenile delinquency, but the juveniles in general. One of them is called our youthful offender status. We have what's called youthful offender status all over the state, and those are people who fall in the category of 18 to 21. So if the crime is committed, alleged to have been committed between the ages of 18 and 21, they can apply for what's called youthful offender status, and therefore they would not be convicted of a crime, a misdemeanor or a felony, but they would be adjudicated to be a youthful offender. They could still serve time in the state penitentiary, they still might have probation, they still might have restitution, they still might have all those things that an adult would have, but they would not have that criminal conviction on their record. And so right now there's legislation pending to extend that age to 26. If y'all can believe that. It's pending right now in the Alabama State Legislature. So we have that one aspect. The other aspect we have is certification of a juvenile as an adult. Juveniles can be certified as adults. You have to go through a hearing before the juvenile court judge, and the state has to file a petition that says we want to certify this child as an adult, we want to try them as an adult, they shouldn't be protected by the juvenile court system anymore, and we want to try them as an adult. And they set out all the reasons why they want that. So there's a hearing about whether or not the state should be allowed to do that, and then the juvenile court judge has to make that decision about whether that child should be certified as an adult.
When would that happen?
When would it happen? Well, there are certain crimes, Class A felonies, which they're automatically, if they're 16 or older, they're automatically certified as an adult, and there's no hearing. If they're under 16 at the time of the alleged offense, then there has to be a hearing for all crimes in front of the juvenile court judge. If y'all remember, if you were a resident here when we had the Discovery Middle School shooting.
Yes.
Okay? There was a big certification hearing held before Judge Sherrod over that case because that juvenile was under 16. If he had been 16, you know, on his 16th birthday or older, then there would have been no hearing. It would have gone immediately to circuit court, well, to the adult court. So what's pending right now is to take that automatic certification away, where the crimes of violence, if there's a gun involved, if it's robbery, first-degree robbery, murder, age 16 or older, there's no certification hearing. The juvenile court judges do not have any discretion about whether that juvenile would be tried as an adult. They would automatically be tried as an adult under current Alabama law, where there's a statute or some legislation pending right now to pull that back, where every juvenile under the age of 18 would have to have a certification hearing in front of the judge. I personally had one of these that it would have been relevant. I think the case turned out like it was supposed to, but to just give y'all an example of how this would work. I had a case, the juvenile was accused of shooting 4 people. Nobody died, but they were accused of shooting 4 people. And he was 2 weeks shy of his 16th birthday. So they had to file a motion to certify if they wanted to do that, which they did. So the prosecutor came up there and just said, he shot 4 people, what more evidence do we need? That's basically what he said. And I said, whoa, whoa, whoa. The statute says we have to go through all these things. And he said, well, he was only 2 weeks shy of his 16th birthday. And I said, well, that's true, but he was 2 weeks shy of his 16th birthday, so let's hear it. So we find out that this kid had 0 record, 0. Okay. Two of the victims had allegedly jumped him. So it was, and there was 3 others involved too, so it was 5 on 1, and he had a gun. Well, you know, well, that sounds like a good self-defense case to me. What else you got? We come up with the third one. The third one was somebody else had said, because there was several people shooting, no, he didn't shoot me. That other person did. I said, well, I looked at the prosecutor. I said, well, we're down to 1 now. What you got now? And the other one said, well, it was an accident. You know, I was holding my hands up and going out the door, and I got shot in the hand. I looked at the prosecutor, and I said, well, I don't think this is looking too good now. And he said, well, I guess I should have read my file. So I guess so. So I said, this is why we should have certification hearings right here. I said, look, I'm going to take this under advisement. We're going to come back in 2 weeks. So in 2 weeks, the DA's office came back and withdrew their petition to certify that juvenile as an adult. So I didn't have to make a decision. But that's a great example of why we need some discretion, because if he had been 2 weeks over his 16th birthday, he'd have a record. You know, and he was a kid. So, you know, that legislation is pending. Oh, we have a question from John Brinkley. Go ahead.
You've been talking a little bit about records for young people, and one of the issues that you brought up before, juvenile certification legislation, was the youthful offender statute. If a person is determined by the judge to be a youthful offender, what could their punishment be? What's it limited to?
Okay. The question is, under the youthful offender statute, what is the maximum punishment if you're adjudicated a youthful offender? I think they use the word conviction for youthful offenders. And the maximum is 3 years in the state penitentiary. And there's a fine up to, help me with the fine, I don't remember what the fine is. I think it's up to $15,000, I'm not sure. That hardly ever comes into play. It's,
You use violence?
well, now, if it's a crime of violence, then the judge is probably not going to grant them youthful offender status. Okay. They might listen to what the facts are about the probable cause, like we do in certification hearings of juveniles. Okay. So, but if it's first-degree robbery, depending on what the facts are, they're probably not likely to get youthful offender status. So you keep in mind that when you're looking at youthful offender status, does the crime that they committed fit the 3-year maximum that's allowed? And so most of the time, the state and the defense attorney agree about youthful offender status. The judges are not called upon very often, or at least I haven't in my experience, and when I was practicing, very often to make the decision on youthful offender status. It's usually by agreement. Or the defense attorney knows it's not ever going to be granted because it's just out there. So, yes, sir.
Is it easier for you, if you get that status, youthful offender, is it easier to get your record expunged than if you're not a youthful offender?
Well, we have an expungement statute here in the state of Alabama, and it was just passed about 3 years ago. The expungement statute applies to some misdemeanors, and I don't have it in front of me. I think it's some felonies. I'm not sure. But the youthful offender status is not specifically addressed in the expungement statute. So I really don't know the answer to your question. I'd have to look it up. It would be statutory whether they're allowed to expunge it. But it's a confidential record. They're sealed, and they're confidential. And there's fines for people illegally accessing those records or using them, or, you know, they keep a real close watch on them. They're flagged in red.
But the important thing about youthful offenders is that it's not even a crime anymore. The ruling or the determination by the judge has decriminalized the bad act, so that the young person who doesn't have enough experience in life would not have this blemish on their record for the remainder of their days. Is that what it's for?
That's true. So the youthful offender statute is designed to have an outlet for that person to have some kind of punishment for whatever they did, but they don't pay for it for the rest of their life on this earth. That whatever they did fits that set of circumstances where it is in the best interest of us as citizens and them as the defendant that they not carry a criminal conviction for the rest of their lives. That whatever they did fits that. Yes,
Judge, I know you lawyers are not old enough to remember this, but I remember how it all got started. What happened is we reduced the age of our men going to Vietnam. They were carrying a gun, but they, you know, weren't adults or were, and so it got down to 18 or 19. But what happened is a bunch of 20-year-old Tuscaloosa rich kids got caught stealing, and they decided that they needed to seal their records too. So, as a result of that fact situation, the whole case, the youthful offender statute was invented for children, adults who were up to the age of 21. And maybe the classic case where it's used is where a young boy drinks beer, has a wreck, somebody gets killed, and he gets charged with vehicular homicide, and in that case gets youthful offender.
I would think it would be unusual for someone who has committed vehicular homicide, although I do remember a case where it occurred. The judge really has to look at the facts. If there's not an agreement between the state and the defense attorney, you really have to look long and hard at what the facts are, and it's just, is it appropriate? I mean, is it in the best interest of everybody for the youthful offender status to be granted? So, yes, sir.
Can you revisit it?
What do you mean revisit it?
Okay, a kid has a drunk car wreck, severely injures or kills somebody. All right, you go to the hearing and they say, okay, you can have youthful offender status. But before the final hearing comes up, he does it again.
Well, you can have youthful offender status for any crime that is committed before the 21st birthday.
But if you get youthful offender status and then it happens again, can you go back and revisit the youthful offender status?
Oh, can you revoke it? Can you revoke it?
Kick him into the adult court.
I don't think it can be revoked. I think once it's given, it can't be revoked.
Not on the same crime, different crime.
Well, the question that was asked is if someone is granted youthful offender status and before they get to trial they commit a new offense, can the first offense, youthful offender status, be revoked? The answer to that is no. Do they get youthful offender status on the next case? They could if it's still under 21. They're probably not likely to get it, but they could. Under the statute, they could get it.
So on the second case, they go to court, but now because the other one was youthful offender status, you can't introduce that as evidence of this is a track record. This guy has done this twice now.
Well, you can't offer that anyways as for evidence of guilt. Prior crimes are not admissible in criminal court as evidence of guilt. They're only admissible at a sentencing hearing. So you can't get them in anyways. All right, so we're going to have to get to capital murder if y'all want to hear about capital murder because we've got 20 minutes left. Capital murder. I was honored to try a few capital murder cases in my earlier days of practice. I served on the Alabama Criminal Defense Lawyers Association Board of Directors for about 7 years, and I graduated from the National Criminal Defense College at Mercer University. My law school was at Alabama. My National Criminal Defense College was at Mercer. And there are about 5,000 lawyers nationwide who have graduated from the National Criminal Defense College. Each year, 2 lawyers from each state are selected twice a year, so 4 lawyers total from each state are allowed to go to the National Criminal Defense College at Mercer. And it is taught by the best criminal justice minds in this country. Judy Clark, if y'all have heard her name before, Judy Clark, she represented Eric Rudolph. She represented Ted Kaczynski. She was one of my professors. And so we learned how to try cases at the National Criminal Defense College, and I was very honored to be able to do that. So you have to have that if you're going to try capital murder cases. And if you're going to defend capital murder cases, if you believe in the death penalty and you go try capital murder cases as a defense attorney, you will never believe in the death penalty again. That's just the way it is. So I haven't met a single one who has tried those cases, who has defended the cases, and is for the death penalty. We don't have the death penalty in every state in the country. I'm sure y'all are aware of that. Alabama has a death penalty statute, as do most of the southern states have a death penalty statute. Alabama's is unique because we have what's called the judicial override. And a judicial override means that if the jury recommends life without parole, that the judge can override that and sentence them to death anyways. And that is currently the scheme, or was the scheme, in the state of Florida. Our sentencing scheme is based on Florida's, and Florida's has been declared unconstitutional within the past few months. That you cannot override, it's unconstitutional to override the jury's recommendation of life without parole to be a death sentence. And so there is some legislation. I'm not up on what the legislation is pending right now, but we have some issues with our death penalty scheme here in the state of Alabama. I think it's called the Hearst case coming out of Florida. The death penalty, implementing the death penalty, there's a cost benefit that I like to look at, that I see as defending them. The work that goes into it is just unbelievable. It will suck the life out of you. If you're a solo practitioner, you've got to shut your practice down for a month to be able to try these cases. They last 2 or 3 weeks. They are very taxing. They will drain the life out of you. But the work that you do is very important because someone's life is at stake, and we have to follow the rules. I mean, if we're going to put somebody to death, then we have to follow the rules. That's all there is to it. And so there's an automatic appeal in these death penalty cases, and any error that the court finds can be brought back to the trial court. In every other case other than the death penalty cases, there has to be an objection on the record. There has to be a preservation of the error on appeal in order for them to pursue their appeal. In a death penalty case, you don't have to have that. It's called, is it the plain error rule? Is that what they call it? The plain error rule. So, yes, sir. What's your question? Capital murder. Capital murder is murder in the course of a whole laundry list of crimes. It's usually armed robbery, robbery in the first degree, like a convenience store killing. That's usually what we find. It can be the murder of a police officer in the line of duty. We've had 2 of those here in Madison County recently that went to trial. Murder and rape is another one. But there's a laundry list of them. I don't know, there's about 7 or 8 of them. And I think they've added to the list. So.
Judge Coates?
Yes, ma'am.
Is there any hope for the young person that goes for those 3 years? It seems that the ones that come back, I only know 2, that they learn things in prison that made them a lot worse as a human being.
Okay, we're back to youthful offender status.
I know, I'm in it fast.
Okay, youthful offender status. Usually if someone gets youthful offender status, they are not going to be sentenced to prison. I mean, the facts of the case are such that it just warrants them not having a conviction. And if it's serious enough that they're going to go to prison for 3 years, they're not likely to have got the youthful offender status to begin with. So, does that answer your question? Did I repeat the question? I don't know if I did for the TV. Okay, so back to the capital murder. The cost to see a death penalty case through to the end is just unbelievable. John, help me with what I haven't done one in years, so I don't know what the current cost is. I mean, it's got to be over $1 million to the taxpayers.
Any person accused of a crime where the death penalty is at stake, they can have, they are required to have 2 attorneys defend them, and the attorneys who are typically appointed are paid by the state of Alabama after the case has resolved itself. They can get some intermittent billing done, but there are expert witnesses that go along with it. Then you've got, of course, the prosecution side of it, and if there is in fact a conviction, there are all types of appeals for those who are for the death penalty and those who are against the death penalty. So it costs society millions of dollars on every single capital murder case that comes up. Presently, there are probably 15 or 20 capital murder cases pending in Madison County. And unfortunately, there is a burden on the courts to have to monitor and maintain these cases, and the lawyers that go along with them. There being 2 on each one, and of course the state has investigators attempting to help in the prosecution, and at least 2 prosecutors on that case as well. So it's very taxing. You'll see that the district attorney's office does choose in some cases not to seek the death penalty, even though it's a capital case, to cut back on some of the resources. So it's trying to be smart with the taxpayers' money when it comes to prosecuting these cases.
So why do we do all this? Why don't we just do like they did back in France and put the guillotine back and, have a trial in a week? Well, the reason we do it is because we have found that we as humans were fallible. And there have been, right here in the state of Alabama, Walter Leroy Moody, is that one of them? I'm trying to remember who has been in the past 15 years, who's been exonerated off of death row. So our judicial system failed us. And how many of those are we willing to accept? How many, from a moral standpoint, is acceptable? And so that's the reason that we have all these protections in place to make sure that we do it right, to make sure that the rules of evidence are followed if you're going to put someone to death. So that's the reason that we have that. We did have, I don't know if it was legislation or there was some, I think it was some kind of legislation. It didn't pass, but I was for that, which is running your federal appeals at the same time as you're running your state appeals. So your appeals process doesn't take so long. So long as you don't give up anybody's appeal rights, if you're running them at the same time, there shouldn't be a problem with that. So you could get them through in 10 years instead of 20 years. But people wanted to cut out the appeals processes. It's just too much. We're just not going to do it. You're just going to get one set of appeals. Well, how do you do that? I mean, you've gone through the justice system. We're all human. For mistakes that could be made, they should have the opportunity, to have their case appealed in the federal system and the state system. So there was a movement. I don't think it passed, but maybe sometime in the future it would, because I think that would be good, is to have those two processes running at the same time. And if they say that they can't in a particular case, have a hearing as to why they shouldn't run the federal and the state at the same time for that particular case. But if they ran them at the same time, that would cut down on the time. It wouldn't cut down on the quality of the review, in my opinion, but it could cut down on the time. Yes, sir?
Yeah, that's correct, because the risk in the parallel appeal is that the federal appeal may not be able to see any error at the state level.
Well, that's true, but if you've got the state appeal going on at the same time as you got the federal appeal, I mean, what happened, happened. That happened back at the offense. So none of the facts are going to change. So you can have two analyzing it at the same time, and there was some movement to do that. I don't think it ultimately has come to fruition yet, but maybe it will in the future. So,
Well, Judge Coates, how does that compare with the person that goes to prison at age 30 and is there till he's 80 or something like that?
I don't think that's the case, but
75, 70?
okay, yes, ma'am.
Food and lodging and us taking care of them.
Oh.
Our taxes.
I understand. Well, to take care of someone life without parole, the cost to do that is less than the cost to prosecute a capital murder case through. Okay? Because they're going to be there 20 years anyways. You're still taking care of them. And you got all this extra cost. And they get all these free lawyers. And they get the Southern Poverty Law Center. And they get all kind of stuff. And if they get life without parole, guess what? They get nothing. They don't get free lawyers. They don't get free appeals. They get one appeal, and that's it. And so they're the ones who are really done. The ones who get the death penalty are really more fortunate than the ones who get life without parole. Okay, yes, sir.
If you go to, when you go parallel for the state and the federal,
When you do what?
when you go parallel with the state and the federal case.
Your appeals process? Yes.
So suppose the federal rules against the state, one rule is favoring the defendant, the other one is just opposite. How do you deal with it?
Well, you know, okay, the question is, how do you deal with the conflicts between the state and the federal appeals process? I didn't read the legislation. It's a good idea. Whether it would work from a practical standpoint, I think it would. And I know enough about the criminal justice system that I think that it could parallel in some respects, and maybe you might have to hold one off till you have one finish, and you could try to do them at the same time. And you could always, you know, have some kind of hearing, some kind of mechanism where in this case it violates the person's rights. Therefore, we can't do it. But I think in a lot of cases you could do it. Alan.
I was just going to point out a couple of things that I do sort of know. I stopped doing the criminal work a while back, but Amy Bishop, Professor Amy Bishop of UAH, the state spent $450,000 on lawyers and experts defending her up to the point where she, in effect, got a life sentence without parole. But hers was a capital case, and the state spent that. Now, I've heard a lot of people say, oh, that lawyer made $450,000. That's not true. There were all kind of experts and people and many lawyers who were involved in trying to make sure that her rights as an American were protected. Another thing, a statistic I heard about 5 years ago was that your average such death case in Alabama took 14 years on appeal before they got to the actual execution, if there was one.
It takes a long time. There's a cost benefit. I respect those who are supportive of the death penalty. I've just personally dealt with it, and it just exhausts you. And those states that don't have the death penalty, they don't have all this that we have to deal with. So, you know, it's just a moral. I respect those people who agree with it, those people who don't agree with it. I'm just telling you that if you meet a defense attorney and they've actually defended one of these cases, I've never met a single one who was for the death penalty after you've done that.
Judge, let me also add this. I keep talking tonight, but I feel like it. I quit doing criminal cases after about 12 or 15 years because the death penalty was reinstated around that time during my practice. And I didn't want to mess with it from a personal standpoint. I had my children and my family, and I just didn't want to be hanging my whole life on some guy on death row. And number two, for 25 years I had been trying to find a lawyer to speak to the People's Law School on the death penalty. And you are the first lawyer that I've known that's actually done it. You actually volunteered it. And I'm overwhelmed because I've asked 25 lawyers in 25 years to speak on the death penalty, and you're the first one who has. Thank you, Judge.
Okay. Well, let me be clear for those, because I think this is going to be on TV. You know, I'm not for the death penalty, not from a moral perspective, but just from a practical perspective. I mean, I think that the death penalty is biblical. I think that there is a place for it, but just the cost benefit of it is just so astronomical that it doesn't make practical sense. So let me clarify it. From a moral perspective, I don't have any problem with it.
You just save it for the right occasions.
Well, that's true too, and hopefully we have that in our cases, the way we implement it. But when you look at the recidivism rate, people say, well, if they have the death penalty, then they'll be dissuaded from committing the crime. Well, if you look at the states who don't have the death penalty, we don't have any less crime, you know, because we have it. Actually, we have more here in the South than they do up in the North where they don't have the death penalty. So that's one of the arguments that's made, which the statistics don't bear out. Another argument is that it's disproportionately applied to minorities, which it is. So, you know, how do you overcome that? So it's just fraught with moral issues that you just get in the quagmire. The lawyers don't want to do it because it just sucks the life out of it. I quit doing them about 15 years ago. I mean, it will burn out the lawyer. So, all right,
Can you
anything
address
else? Yes, sir.
One thing about the federal government who is allowed to do deficit spending, but the state who can't do deficit spending, and the federal government calling the Florida case unconstitutional, got to change stuff. Is that not some of the conflict, and the state of Alabama paying the attorneys who have to go through the appeals and stuff because of the federal government's requirements? Do you understand what I'm talking about?
I don't think so. John, did you understand the question? Can rephrase it?
Well, I would point out that the state of Alabama does not pay the redheaded stepchildren, the criminal defense attorneys. We're the first ones to get cut every single time. I know that comes as a shock to TV land. But the other thing I would point out is that for those of you who want to hate the criminal defense attorneys, roughly half of the attorneys who take these court-appointed cases, they're working at 25% their normal rate. So what I would tell you is that typically these lawyers are billing at $300 an hour. If you get the opportunity to represent someone who's been appointed to you by the court, you're making $70 an hour. So it comes at quite the shock to somebody's system. So suddenly they slash your salary from what it is to 25%. You know, you're really doing this because you have a calling for it and to protect that person's rights. But the state of Alabama does cut its spending. Its fiscal year ends September 30th, and the funds are gone sometime in late August on a typical year. Last year, the criminal defense attorneys here locally stopped getting paid in June or July, and the faucet didn't cut back on until November. So not only are you getting paid 1/4 of the rate, but also you don't get paid on a regular basis. So Christmas gets thin sometimes. And I just alert you to that because we do have some of these capital cases where a whole lot of money gets spent, but the minute you start taking away the rights of the less fortunate or the least fortunate, who's next?
Let me say also, when the country was founded, we had these Bill of Rights that Alan just mentioned a minute ago. The reason we have the Bill of Rights is because in England, the criminal justice system was set up that you couldn't have a lawyer. You had to prove your innocence. And so that's why our justice system is set up the way it is because of the abuses that occurred in England with that criminal justice system. So that's why we have the right to counsel. That's why we have the right against self-incrimination. That's why we have the presumption of innocence, because our founding fathers decided that this is the way our criminal justice system is going to be. And so that's how it came about. It's not that we want people to get off, it's that we decide that we would rather err on the side of freedom than err on the side of people going to prison who are innocent. And so that's the whole premise of it. So if you keep that in mind when you're looking at the criminal justice system, then it starts to make better sense. And the defense lawyers who are good attorneys are not seeking to get someone off. They're seeking to make sure that all the constitutional rights have been protected, that the confessions are not illegally obtained, because what happens when the confessions are illegally obtained and that they get to use them anyways? Then the police will just keep doing it. So what do we do? So you have to follow the rules, and if you follow the rules, then you'll get the conviction. And if there's any error, we as a society decided back in 1779, when we passed the Bill of Rights, that we were going to err on the side of people who might be guilty going free than people who are innocent being locked up. That's what we decided we would do. So that's the whole premise of it.
So your question is, what does it mean when the judge says to your objection, he says overruled? That means you didn't win. If he says sustained, that means you're doing good, and then the other side can't do what they wanted to do in your case. But, you know, we were talking about judges, George and I were a little while ago, and we were talking about judges' latest rulings, you know, stare decisis, things like that. What does all that mean? And it means the latest ruling in a particular case is what the judge is supposed to do in your case, if it's an identical case. And so we were arguing this case one time, and I kept saying, Judge, but this and this, and this is what you must do, and whatever. He went, bam, he said, Alan, I just overruled you. You got anything later than that? So those are the kinds of things you put up with. And I always think about this, the Charlie Hooper moment when he was a prosecutor and somebody like Phil was the defense attorney, and the drug addict had not done what he was supposed to do prior to trial. He had stayed on his drugs or whatnot. And so Charlie Hooper said, well, I'm just going to reluctantly, I know I said I would recommend probation, but I'm just going to reluctantly recommend probation. And Judge Snodgrass looked at him and he said, well, I'm just going to reluctantly grant it.
Would take a case on a contingency fee basis, and typically that's a case where a person has money that they believe that they're entitled to. Cases such as a collections case, a car wreck case, medical malpractice case. Those are the types of cases that you can take under a contingency fee basis. There are different types of cases for example, in an alimony or a child support type case where you cannot take a contingency fee based on what you recover, but instead you would work by the hour. Contingency fees can range anywhere between typically a third up into about a half of the total recovery. There are certain cases that you'll hear about, for example, Social Security disability, that have limited fees where the attorney can only recover 25% of whatever they've collected on the back pay, or even in a workers' compensation case where they're limited to 15%. And some of that's governed by statute as well as other applicable law.
The hardest thing for me is people will often say, how do you defend somebody that's guilty? And that's an easy question. The greatest generation, greatest group of men ever gave us a Constitution, United States Constitution, and it says the government's got to do certain things. Prove you're guilty beyond a reasonable doubt. You have presumption of innocence. And there's nothing easier in the world for me than to defend a guilty person, because then I feel like I'm doing a civic duty for the community, making the government go through their paces to prove my client's guilty. Now, I generally try to focus and specialize on innocent clients, and those are always the tougher ones, because if a guilty man is found guilty or a guilty woman is convicted, hopefully they're just going to get just rewards. The concern is an innocent person being convicted on my watch, then the system's failed. And to me, and people love the adage, better that 9 guilty people go free than 1 innocent man go to prison. And this is the absolute truth, because when they're sitting there beside you and you just know that they're innocent, it's a great weight on your shoulders. It's always tough trying a case. But like I said, having an innocent person beside you, it's a great weight, and that's what puts the weight on and takes the hair off.
The question is that in a multiple plaintiff claim or a class action lawsuit, it sounds like the injured party doesn't receive as much money. However, the injured party in a case such as what you described, let's say a videotape return agency, back when VCR tapes were popular, there were late fees that were assessed and things of that sort. And although the individual consumer only received a small portion of what the total settlement was, there were a lot of lawyers and a lot of hours that went into that, along with expenses that go along into the prosecution of claim. So, and it did stop the bad act. It may not have been criminal per se, but it did stop the bad action. And so that's one of the reasons why we have attorney's fees, is because, frankly, the government can't babysit all the bad actions that go on in society. And so fortunately, we do have lawyers that can go out there and fight for the individual person.